Welcome to Transnational Competition Law course, and today, dear learner and viewers, I am going to discuss the extraterritorial application of competition law in United States. And you may rightly recall that the previous lecture happens to be about the theories and principles of extraterritorial application of competition law. Now we will begin with the extraterritorial application of competition law in United States. In this lecture, dear learner and viewer, I will just discuss first and the foremost the Sherman Act 1890, the Clayton Act 1940, and the decision of the United States Supreme Court in United States versus Aluminum Corporation Company of America, popularly known as Alcoa case in 1945, Racketeer Influenced and Corrupt Organization Act 1970, Foreign Trade in Antitrust Improvement Act 1982, and restatement third of the Foreign Relation Law of the United States of 1988 to give an overview of the legislative framework of extraterritorial application of competition law in United States. Then we will be discussing in a very specific term of reference to the Sherman Act. We will take note of Article 1 and 2 of the Sherman Act, then Section 111 of the Sherman Act, and we understand that Section 111 Sherman Act 1890 prohibits conspiracy that unreasonably restrain the trade. Under the Sherman Act 1890, the agreement among the competitor happens to be what you can call to fix the prices or wages, rig bids, or allocation of customers, workers, markets as considered to be punitive and the criminal violations. Then, in the context of Section 1 and 2 of the Sherman Act and Section 111 of the Sherman Act, we will be referring to Timberlane Lumber Company versus Bank of America National Trust and Saving Association decision of 1983. Then we will be discussing the Hartford Fire Insurance Company versus California decision in 1993. And then we will try to establish as to how the effect doctrine, which has been laid down in Alcoa case in 1945, is being permeated under the Timberlane Lumber Company and Hartford Fire Insurance Company of California in 1993. And then the impact of the effect doctrine will be underlined in our discussion to have a grasp of extraterritorial application of competition law in United States, taking cognizance of the fact that how the effect doctrine under the garb of conduct and effect and sufficient and direct kind of a nexus and relationship doctrinated the entire purview and the ambit of the extraterritorial application of competition law in United States. Then, dear learner, we will be switching over to the other doctrines, namely the legitimate sovereign interest doctrine, which has been laid down in United States versus Bowman in 1920. It was also being affirmed in Shokunban versus the First Brook in 1970 and in Lisco Data Processing Equipments Corporation versus Maxwell in 1972 and Bush versus Drexel Firestone Incorporation 1975 and IIT versus Wencap Limited 1975. In the light of the ratio and an arbiter of this decision, We will try to understand that what is the doctrine of legitimate sovereign interest applied in the case of the extraterritorial application of competition law in US by the courts of United States of America. Then we will be switching over to, dear learner, what can be called as jurisdictional rule of reason, which was laid down by Justice Adam in Mannington Mills Incorporation versus Conglium Corporation in 1979 and in Mauritian versus National Australian Bank Limited in 2010. Having understood the nature and scope of the jurisdictional rule of reason, we will be referring to or switching to the presumption of statutory intent doctrine, which has been laid down under various case law, and these cases happens to be RJR Nabisco Incorporation versus European Community 2016 decision, wherein the court examined in detail the presumption of statutory intent of Racketeer Influenced and Corrupt Organization Act of 1970 and its relevance under the Sherman Act and Clayton Act and the competition law and the antitrust law. Then another doctrine which has been referred to known as conduct and effect test, which is being confirmed and incorporated under Dodd-Frank Wall Street Reform and Consumer Protection Act 2010, containing a specific provision, namely Section 929PB for extraterritorial jurisdiction of securities law and analogically to be applied in competition and the antitrust law. Then it will be very pertinent to note that the Foreign Trade Antitrust Improvement Act in 1982, passed by the United States Congress, created an antitrust liability having import, commerce, and direct, substantial, and reasonably foreseeable effect on domestic commerce under the Sherman Act of 1890 and the Clayton Act of 1940. Then it will be advisable for us, dear learner, to look at the salient feature of the Foreign Trade Antitrust Improvement Act, which was passed in 1982, as to see how they govern the application of the Sherman and Clayton Act to antitrust violation which takes place in foreign territory and jurisdictions. Then another milestone under the extraterritorial application of the competition law happens to be the restatement third of the Foreign Relation Law of the United States passed in 1988, wherein the section 402, 403, and 415 of the restatement third can be summarized as the principles of reasonableness, and the salient features of these three sections taken together cumulatively means that territoriality, nationality, and the effect doctrine with that of the doctrine of reasonableness. Thus, the restatement third added further that a state has jurisdiction to prescribe law with respect to the conduct outside its territory that has or is intended to have substantial effect within its territory. Then, after perusing all the case law and all the legislative development which have a direct and incidental bearing on the extraterritorial application of competition law, we'll be in a position to discuss the ambit, scope, and purview of the extraterritoriality in United States in the light of the Sherman Act, Clayton Act, and other auxiliary and analogous or incidental statutes, emphasizing upon that how the extraterritoriality has been applied to all harmful business practices, anti-competitive practices, and how to fix the liability on non-nationals outside US jurisdiction and to see the consequences of American and the foreign jurisdiction on the issue of the antitrust and the competition law. Then we will be discussing the divergence of the various case laws and legislative scope, and we'll find that what are the congruence and agreements in courts' use of conflict of law principles, and in a way balancing of the interest principles laid down in Timberlane case and Hartford fire case to see the exactly the entire prism of the extraterritorial application of the competition law. Dear learner, with this introductory and synoptic overview, we will directly discuss the first part of my lecture, which deals with the Sherman Act 1890 and Alcoa decision of 1945. As I have referred, that extraterritorial application of competition law in United States begins with Sherman Act 1890 and United States versus Aluminum Company of America, popularly known as Alcoa Case 1945. The antitrust law and the judgment combined together play a very pivotal role in international legal governance and overall geo-economic strategies. The extraterritorial application of competition law under the US Federal Statute determines the application of US law to partial manner outside the territory of the United States. The Supreme Court applied the traditional presumption against extraterritoriality, inconsistently ignoring the presumption when limiting provisions to conduct within the United States would have defeated the apparent purpose of a statute. The U.S. antitrust law provisions, particularly Section 1 and 2 of the Sherman Act 1890, give rise to extraterritorial jurisdiction in the cloak of the effect doctrine laid down in Alcoa case in 1945. Since then, the U.S. antitrust jurisdiction of extraterritorial jurisdiction started and followed by many leading judgments. The Foreign Trade Antitrust Improvement Act of 1982 creates an antitrust liability having import commerce and direct, substantial, and reasonable and foreseeable effect on domestic commerce under Sherman Act 1890 and Clayton Act of 1940. The restatement third of the Foreign Relation Law of the United States 1988 incorporated the rulings of the U.S. Supreme Courts as well as the jurisdictional rule of reason in antitrust cases involving foreign parties. Now, dear learner, we'll be discussing some of the salient features of the key enactment on antitrust or competition law known as Sherman Act 1890. And then we examine that act to locate the nature and extent of extraterritorial application of competition law. According to Section 111 of the Sherman Act, every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among several states or with foreign nations is declared to be illegal. It further stated that every person who shall make any contract or engage any combination or conspiracy hereby declared to be illegal shall be deemed to be guilty of felony and conviction and will be punished by fine. The provisions of the Sherman Act applies to foreign restrictions of competition, provided that the foreign practices causes significant effect in the USA's effect doctrine and laid down in Timberlane Lumber Company versus Bank of America National Trust and Saving Association in 1983 and Hartford Fire Insurance Company versus California in 1993. The effect doctrine was first applied in the context of Alcoa case, where the US court held that the Sherman Act applies even upon person not within its allegiance for conduct outside its border that has consequences within its border which the state reprehends. Thus, the court in Alcoa case found antitrust violation and applied the Sherman Act extraterritorially. This was due to the fact that the foreign conduct showed negative effect in the US and as such effect was intended. Now, dear learner, we will be discussing what are the basic precepts and the practice of the impact of the effect doctrine laid down in Alcoa case. The US courts often exercise extraterritorial jurisdiction in the context of antitrust law based on the extension of objective territoriality principles and using so called effect doctrine. The effect doctrine, first introduced in the opinion of Justice Hand in US versus Aluminum Company of America 1945, to determine the conduct and effect and sufficient and direct test. Thus, Justice Judge Hand stated that a state may impose liabilities even upon person not within its allegiance for conduct outside its border that has consequences within its borders which the state reprehends. The doctrine established that a state can assert jurisdiction over conduct outside its borders where such conduct has intended effect of causing substantial adverse impact within the state's territory. Justice Hand's decision further goes on to state that a state may impose liabilities and even upon a person not within its allegiance for conduct outside its border that has consequences within its border which the state reprehends. Thus, what we see that the US Supreme Court confirmed Justice Hand's opinion in its decision known as Hartford Fire Insurance Company versus California in 1993 and endorsed the substantial effect test applies to Sherman Act 1890 to foreign conduct that was meant to produce substantial effect in United States. Now, dear viewer and learner, we will be discussing the legitimate sovereign interest because the extraterritorial application of competition law comes directly in conflict with the legitimate sovereign interest of a particular country or the territory. Therefore, the impact of the effect doctrine eliminates into many judicial doctrine in subsequent ruling on extraterritorial application of competition law. A balanced approach, however, has developed between the sovereign and legitimate sovereign interest. Here we have to bifurcate and dissect as to what is called as the sovereign interest and what is called legitimate sovereign interest. The US courts in F. Hoffman Law Roque Limited versus Impagran SA 2004 laid down that the US Congress takes the legitimate sovereign interest instead of the sovereign interest of the other nations with respect to extraterritorial reach of the US statutes. It means that it takes cognizance of the risk that overreach might lead to serious risk of interference with foreign nations' ability to independently regulate its own commercial affairs. The Second Circuit ruling in a famous case of United States versus Bowman in the year 1922, Ishcoin-Baum versus First Brook 1970, Lisco Data Processing Equipment Corporation versus Maxwell in 1972, and Burks versus Derexel Firestone Incorporation 1975, and IIT versus Venkap Limited 1975 invariably applied securities law in extraterritorial terms. Thus, in Timberlane Lumber Company versus Bank of America National Trust and Saving Association, the American antitrust laws were applied to the activities in other countries, including the action of foreign government officials.